Mr. Professor Sylagi, gentlemen, dear colleagues, the free assessment of the evidentiary material constitutes the culminating stage of administrative proceedings and consists in determining the conformity of the collected material with the true. A particular issue is the assessment of evidence from official documents, to which Article 76, Section 1 of the Code of Administrative Procedure attributes enhanced, stronger probative force. This provision expressly refers to Polish documents. Foreign official documents as admissible means of evidence should be assigned the same legal effect, and this by way of reasoning per analogiam and from the nature of the matter. The main problem, however, is to resolve the conflict between the stronger probative force of official documents and the principle of free assessment of evidence. The pursuit of objective truth is determined by the system of evaluating evidence. Historical evaluation distinguishes three principles. First, the principle of legal formal assessment of evidence, the second principle of arbitrary assessment, and the currently adopted principle, the free assessment of evidence. In Polish law, the last principle is expressed in Article 80, pursuant to which a public administration authority shall assess on the basis of the entirety of the evidentiary material whether a given circumstance has been proven. Within the framework of the free assessment of the evidentiary material, the authority decides on the following two: relevance, probative force or lack of probative force, authenticity and credibility of individual items of evidence from the perspective of the evidentiary thesis formulated in the case. The meaning of these concepts is on the slide. Free assessment is a mental process of the authority or court which covers in a broad sense from the assessment of relevance, probative force, authenticity and credibility of the entirety of the evidential material. In a narrow sense, this is the assessment of the credibility and authenticity of specific item of evidence combined with the selection of the evaluation rule. The essence of the free assessment of evidence is therefore linked with the absence of constraints on the authority in the form of formal legal, rigid evidentiary rules requiring the evidence be assessed in a prescribed manner, and with their replacement by an assessment made according to rule established by the authority itself, derived from the authority's own conviction, yet accompanied by an obligation to justify the mode of assessment in a way that allows for external review. These rules are thus determined by reason and rationality. In general, the provision of the Code of Administrative Procedure do not impose rules for valuing specific items of evidence, practice, and legal scholarship, however, indicate the necessity of choosing criteria appropriate to sphere of legal relevant facts to be proven. One must distinguish material, culture, and mental facts. For their determination, the following evaluation rules are distinguished. First is the rule of linguistic conformity. Second is the rule of conformity with scientific knowledge. Next is the rule of formal logic. Next, the rule of rationality. Next, the rule of common sense. And last, the legal rule on which more below. The system of rules is hierarchical in nature. The freedom of assessment is limited when absolute laws of science and logic are applied, and it increases when culture, rationality, and common sense are used. However, it may not turn into arbitrariness. It must be based on the entirety of the evidence in a verifiable manner. Enhanced probative force of an official document. Article 76, Section 1 provides that official documents drawn up in the prescribed form by competent state authorities within the scope of their competence constitute proof of what has been officially stated therein. This establishes a double presumption: first, conformity with the truth, and second, authenticity. If foreign documents meet requirements analogous to those set out in Article 76, Section 1 and second, they should be attributed stronger probative force, namely the same force as the that enjoyed by Polish document. Now about the mentioned legal rule. The legal rule is expressed each time by an explicit provision of law. In its positive version in abstracto, such a provision requires that specified material facts be regarded as proven in accordance with the evidentiary rules expressed in that provision. If the circumstance indicated in the provision of law. The positive version of the legal evidentiary rule has been adopted under Article 76, Section 1. By way of reasoning per analogiam leges, this rule is also applied to foreign official documents. The solution adopted constitutes a departure from the general principle of equal probative value of all evidentiary items, since it grants official documents at the outset a stronger probative force and requires the circumstances stated in the content of an official document be regarded as material facts that have been proven. This means that the essence of the legal rule is exclude an evidentiary item and the fact regarded as proven by means of that item under this rule from free assessment of evidence in the narrow sense, unless that fact is challenged by a part other doubts arise on the part of the authority. An official documents is thus assessed by the authority in a manner different from the applied to other evidentiary materials. The authority asks whether the facts officially stated are true only if doubts arise in this respect. In the case of other evidentiary materials, the authority is obliged always to ask whether they are true and to conduct an appropriate reasoning that yields a positive answer. This does not mean, however, that an official document is not subject to any assessment. The waiver in the cases indicated above of the free assessment in the strict sense may be possible because the authority previously poses questions as to the relevance, probative force, and authenticity of the official document and gives positive answer to them. This leads to the conclusion that the legal solutions adopted in Article 76 Code of Administrative Procedure result in a different cause of the mental process directed at the free assessment of an official document. It is therefore assessed by the authority in a manner different from other evidentiary materials. This excludes the presumption resulting from an official document from typical free assessment of evidence in the narrow sense. Initially, the authority examines only authenticity, relevance, and probative force, recognizing the content of the document as a proven fact. The increased, stronger probative force of an official document is not absolute in nature. Pursuant to Article 76, Section 3, it may be rebutted by counter evidence. Literally, the Polish legal system does not create a conflict of laws rules for such situation, and therefore the conflict between an official document and counter evidence is resolved through free assessment under Article 80. Code of Administrative Procedure. Although counter evidence may take the form of any item of evidence, its rank imposes limits on the rules of evaluation employed. In order not to circumvent to the purpose of Article 76, Section 1, the overcoming of the enhanced probative force must take place by reference to objective and verifiable criteria, scientific knowledge, formal logic, and the rigors of linguistic conformity. The use of common sense criteria alone should be considered excluded in such a case. The rule of rationality causes the greatest difficulties. In principle, it should be excluded from use in such situation, yet it cannot be entirely rejected. The fact that the document has been challenged must be reflected in detail in the statement of reasons for the decision, indicating the reason for rejecting the document, the counter evidence adduced, the evaluation rule applied, and the conclusions drawn. Free assessment in a procedural law concept and it appears at many stages of the fact-finding phase. So we may distinguish inter alia the ongoing assessment, the final but not definitive assessment, and the definite assessment. Decisional discretion increases most significantly during the assessment of the entirety of the evidentiary material. Its basis is the principle of equal probative value of all items of evidence. The stronger probative force of a foreign or Polish official document may also be overcome as a result of a collective assessment of all other evidence and circumstances, even if none of them taken individually would suffice to overcome Article 76, Section 1. Conclusions. The legal rule excludes the application of other rules for assessing official documents which are accepted in light of particular legal tradition as rules for valuing the probative force of evidence in administrative proceeding. It requires that a fact indicated in an official document be accepted as proven without to need to assess its credibility, provided that the official document is authentic, has probative force, and is assessed as relevant in the given case. This means that an official document and the fact indicated in its content are not subject to free assessment of evidence in the narrow sense. The authority or court must accept the fact resulting from the content of the official document as true. This is dedicated by the need to ensure legal certainty in the legal transaction within which a given official document operates and is effective as an element of a specific reality. The possible rebuttal of the enhanced probative force of an official document in administrative proceedings becomes possible only when the authority or a party harbors doubts as to the content of the official document and considers that it is not consistent with the reality. Formal rebuttal of the double presumption of authenticity and conformity with the truth may occur either through specific counter evidence or through a global assessment of the entirety of the evidentiary material. However, to overcome the stronger probative force of an official document, it is necessary to demonstrate doubts by applying strong criteria, scientific knowledge, formal logic, and linguistic rationality. Thank you.